Hadirin dimohon berdiri. The Honorable James Leslie Ben Allsop, Ketua Federal Court of Australia, didampingi Yang Mulia Bapak Syamsul Ma'arif dan Kepala Badan Litbang Diklat Hukum dan Peradilan Mahkamah Agung memasuki ruang acara. Hadirin kami persilakan untuk duduk kembali. Mohon izin Bapak Ibu bisa maju ke depan terlebih dahulu mengisi yang kosong. Agar barisan depan terpenuhi dulu. Assalamualaikum warahmatullahi wabarakatuh. Salam sejahtera bagi kita semua. Shalom, Om Swastiastu, Namo Buddhaya, salam kebajikan. Yang Mulia, The Honorable James Leslie bin Allsop, Ketua Federal Court Australia. Yang Mulia, Bapak Syamsul Ma'arif, SH, LLM, PhD. Yang terhormat, Kepala Badan Litbang Diklat Hukum dan Peradilan Mahkamah Agung, Bapak Bambang Heri Mulyono, SHMH. Yang kami hormati para pejabat eselon 2 pada Badan Litbang Diklat Hukum Dil Peradilan Mahkamah Agung Republik Indonesia. Yang kami hormati para hakim tinggi dan para hakim justisial pada Mahkamah Agung Republik Indonesia. Para ketua pengadilan tingkat pertama, para hakim pengadilan niaga Pengadilan Negeri Jakarta Pusat, tim pembaruan Mahkamah Agung, tim reformasi hukum ekonomi EIPJ, para pejabat struktural pada Badan Litbang Diklat Kumdil Mahkamah Agung, para peserta yang menyaksikan melalui Zoom dan live streaming YouTube, serta para undangan dan seluruh peserta yang berbahagia. Selamat pagi, kami ucapkan selamat datang di Badan Litbang Diklat Hukum dan Peradilan Mahkamah Agung Republik Indonesia. Puji syukur kita panjatkan kehadirat Allah Subhanahu wa Ta'ala, Tuhan Yang Maha Esa, atas berkat rahmat dan hidayahnya sehingga pada hari yang berbahagia ini kita dapat berkumpul untuk melaksanakan acara ceramah umum dan yang akan dilanjutkan penanaman pohon memorabilia oleh Chief Justice Federal Court of Australia bertempat di Badan Litbang Diklat Hukum dan Peradilan Mahkamah Agung pada hari ini Selasa 21 Maret 2023. Hadirin yang kami hormati, mengawali seluruh rangkaian acara pada hari ini, marilah kita buka dengan bersama membaca basmalah. Bismillahirrahmanirrahim. Sebelum memulai seluruh rangkaian kegiatan pada hari ini, akan kami bacakan terlebih dahulu susunan acara sebagai berikut. Pertama, pengantar singkat acara ceramah umum oleh Kepala Badan Litbang Diklat Hukum dan Peradilan Mahkamah Agung. Kedua, ceramah umum oleh The Honorable James Leslie bin Allsop dan selaku moderator Yang Mulia Bapak Syamsul Ma'arif SH LLM PhD. Sesi foto bersama dan dilanjutkan pelaksanaan penanaman pohon memorabilia di Taman Hatta Ali. Baiklah Bapak Ibu hadirin yang berbahagia, langsung saja marilah kita dengarkan pengantar singkat acara oleh yang terhormat Kepala Badan Litbang Hukum dan Peradilan Mahkamah Agung Republik Indonesia, Bapak Bambang Heri Mulyono SHMH, kami persilahkan.
Selamat pagi. Ini sepi sekali ya. Buah cempedak rasanya.
Recording in progress.
Hadir banyak yang jawab sedikit. Selamat pagi. Alhamdulillah. Assalamualaikum warahmatullahi wabarakatuh. Yang kami muliakan Honorable Justice James LB Allsop, Ketua Federal Court Australia. Yang kami muliakan, Yang Mulia Hakim Agung Bapak Samsul Ma'arif. Yang kami muliakan teman-teman para hakim tinggi, para hakim justisial, para pejabat di BLDK, serta para ketua pengadilan se-Jabodetabek yang sengaja kami mengundang hadir ke BLDK karena ini ada kesempatan yang sangat baik. Beliau dari tetangga dekat kita, dari Australia, datang ke Indonesia dan menyempatkan diri untuk datang di kampus kita ini, Pusdiklat Mahkamah Agung, yang sudah kita sama-sama luncurkan Mahkamah Agung Corporate University. Mudah-mudahan pagi hari ini kita bisa banyak diskusi dalam suasana yang penuh keakraban. Beliau adalah berdua antara nanti Yang Mulia Pak Samsul Ma'arif dan Justice Allsop ini selain sebagai Hakim Agung juga sebagai guru. Nah, mudah-mudahan nanti ada diskusi yang menarik di antara kita bahwa hakim ini juga bisa selayaknya sebagai guru bangsa melalui putusan-putusannya yang kira-kira juga mengungkap hal yang sifatnya filosofis. Nanti akan banyak sekali yang bisa kita ambil dari hasil ceramah beliau. Saya ucapkan selamat datang untuk semuanya. Mudah-mudahan bisa kita menikmati suasana diskusi pada pagi hari ini dengan sangat baik dan insya Allah bisa bermanfaat untuk kita semua. Terima kasih. Sambutan singkat saya aturkan. Kurang lebihnya kami mohon maaf. Billahi taufiq wal hidayah. Wassalamualaikum warahmatullahi wabarakatuh.
Terima kasih Bapak Bambang Heri Mulyono atas kata pengantar singkatnya. Baiklah Bapak Ibu hadirin yang berbahagia, langsung saja kita akan masuk pada ceramah umum yang akan disampaikan oleh The Honorable James LB Allsop dengan moderator Bapak Yang Mulia Bapak Syamsul Ma'arif SH LLM PhD. Untuk itu waktu dan tempat kami persilakan.
Assalamualaikum warahmatullahi wabarakatuh. Salam sejahtera untuk kita semua. Yang saya muliakan Chief Justice Federal Court of Australia, Profesor James Allsop. Saya panggil beliau profesor karena beliau juga selain Ketua Mahkamah Agung, beliau juga mengajar. Yang saya hormati dan saya muliakan para hakim tinggi, para ketua pengadilan tingkat pertama se-Jabodetabek, para pejabat dan rekan-rekan tim pembaruan. Bersyukur kita bisa hadir pada hari ini dan lebih bersyukur lagi kita bisa ketemu dengan Chief Justice James Allsop pada hari ini. pemikiran, perspektif ke depan. Sebagai hakim atau being judge, kita tidak bisa hanya membaca undang-undang kemudian melaksanakan, tetapi kita juga harus punya perspektif. Bagaimana kita menyelesaikan sengketa secara adil. Saya ingin meng-quote saja salah satu tantangan kita dari perspektif dunia. Bank Dunia itu memplototi gitu ya, mengawasi, monitor perilaku dan performance pengadilan sejak tahun 2012. Ada dua indikator yang disurvei oleh Bank Dunia. Indikator yang pertama, sejauh mana kita bisa menyelesaikan sengketa kontrak dengan baik dan tepat, cepat, murah, efisien, ya, tidak bertele-tele. Kemudian yang kedua, bagaimana kita bisa menyelesaikan perkara kepailitan. Dua ini yang dimonitor oleh Bank Dunia sejak tahun 2012. Nah, rupanya kita juga tidak bagus, paling tidak belum baik dari kacamata mereka ya. Saya ingatkan saja, mungkin banyak di antara kita juga sudah pernah membaca ranking kita untuk isu penyelesaian sengketa kontrak tidak banyak berubah dari tahun 2012 sampai 2022. Pada posisi ranking berapa? Kita berada pada posisi 130 pada tahun 2012, ranking kita berada pada ranking 130 dari 190 negara. Tahun 2002 naik kita, luar biasa naiknya. Kita berada pada ranking 73 dari 190 negara. Jadi meskipun ada kenaikan, tetapi dibandingkan dengan negara-negara lain, kita masih jauh di bawahnya. Di ASEAN saja, kita berada di bawah Malaysia. Malaysia itu ranking 12. Malaysia, kata Bank Dunia, menyelesaikan sengketa kontrak itu bagus. Rankingnya 12 dari 190 negara. Kita 73. Kita 130. Vietnam secara umum berada pada ranking 70. Kita secara umum pada ranking 73. Jadi kita berada di Vietnam. Untuk kontrak, saya ulang, untuk kontrak tahun 2012 ranking kita berada pada angka 145, sorry tadi saya salah, bukan 130. 145 dari 190 negara. Naik 139. Jadi dari 145 sekian tahun naiknya hanya sekian ranking 139. Untuk perkara pilot, alhamdulillah kita naiknya luar biasa. Tahun 2012 kita berada pada ranking 149 dari 190 negara. Naik luar biasa tahun 2022 pada ranking 38. Jadi PR kita yang fokus sekarang adalah, kata mereka, kata Bank Dunia, we have to do many things untuk membangun sistem penyelesaian sengketa kontrak ini. Ini survei ini memang berakhir tahun 2002, tapi ini akan dilanjutkan dengan survei lain namanya BII, Business Enabling Environment Index. Itu akan dimulai nanti bulan depan, April. Yang akan disurvei hampir sama. Satu, apakah kita pengadilan bisa menyelesaikan sengketa kontrak dengan baik, cepat, efektif. Termasuk kontrak-kontrak internasional. Kemarin Pak James Allsop bicara banyak tentang tantangan pengadilan ke depan berkaitan dengan sengketa komersial internasional. Nah, mungkin pada hari ini kita tidak akan bicara terlalu teknis ke sana, tetapi ini menunjukkan bahwa sebagai hakim kita harus siap menghadapi berbagai isu baru, ya. Apakah isu komersial internasional, kontrak internasional, termasuk perkara-perkara yang disorot oleh publik. Dinamika perkara berkembang sesuai dengan perkembangan zaman. Jadi kita sebagai hakim juga tidak bisa stick pada satu perspektif, selalu harus berkembang. Nah, pada hari ini kita sangat bersyukur karena ada resource person yang pas ini, bahkan lebih pas gitu ya, untuk berbicara tentang bagaimana menjadi hakim ke depan, being a judge in the future. Saya pribadi sangat bersyukur karena Australia kalau melihat indikasi survei tadi luar biasa gapnya dengan kita ya, jauh sekali. Saya lihat kemarin dari data yang ada, untuk enforcing kontrak itu Australia berada pada ranking 6. Kita berada pada ranking 139. Jadi kita bisa belajar baik dari segi teknis maupun being a judge untuk menghadapi sengketa-sengketa ekonomi, sengketa komersial, dan sengketa lain ke depan. Pak James, seperti tadi dinyatakan oleh Pak Kepala Badan, beliau orang yang pas. Kalau saya bisa sedikit cerita tentang CV beliau, sebelum jadi Ketua Mahkamah Agung, beliau adalah advokat selama 20 tahun di New South Wales. Dan tentu saja di beberapa negara bagian Australia. Beliau juga menjadi hakim Federal Court di tingkat banding, itu hampir 7 tahun, sebelum akhirnya diangkat sebagai Ketua Mahkamah Agung selama 10 tahun, mulai Maret tahun 2013, bulan depan beliau pensiun. Jadi waktu saya dan Pak Arya berkunjung ke Sydney, beliau cerita, sebelum saya mengakhiri tugas, saya ingin sekali ke Jakarta. Because Jakarta is my best place. I have a lot of friends in Jakarta, jadi I was honored to hear that. Saya merasa tersanjung mendengar itu, dan betul beliau komit untuk hadir pada hari ini. Kita ada waktu 2 jam sekitar, jadi setelah pengantar ini berarti sudah kurang setengah jam. Kita berakhir sampai dengan jam 11. Feel free untuk bertanya, kita siapkan penerjemahnya. Kami persilakan Pak James untuk menyampaikan perspektifnya being judge ke depan. It's up to you, sir, about the time, but we only have 1.5 hour, and we expect to have lots of questions within about 30 minutes. Please.
upon us, and peace be upon us. Thank you for having me speak to you, experienced judges, new judges. We are all judges. We are all judges, and the things I wish to speak about today, I have been thinking about for a long time. There are two groups of ideas I wish to talk about today. The two groups are related, the ideas are related to each other, and they come from two speeches I gave to two different groups of people in the last year. One was to the dinner in Papua New Guinea at Port Moresby, which was a dinner that the bar, the profession and the judges have each year, called the Bench and Bar Dinner. And it was entitled Being a Judge, What It Is to Be a Judge. The other lecture was given a little bit earlier last year in London to one of the Inns of Court of barristers, and it was about legal thinking, how we think about the law, and some of the important ideas that assist in understanding how we think about the law from understanding our brains, how our minds work. Neither is particularly difficult. But they are neither topic is particularly difficult, and they are related, as we will see. By way of introduction to my being a judge, we have a completely different system of how lawyers become judges in our country. Common law countries and civilian countries tend to recruit their judges in quite different ways. I don't think one system is better, it's just what it is. We recruit judges from the profession, sometimes from the universities, but mainly from the profession, at a point where someone has become reasonably senior in the profession. So I practiced for 21, 22 years before being appointed a judge. And we do not, though we have judicial training, we do not have it anywhere near as systematic and as thorough as civilian countries such as Indonesia, where people choose at a young age to become judges as a career path. But ultimately, in my experience in meeting judges from many countries over the last 22 years now that I've been a judge, we all do the same thing, and we all face the same challenges. And I hope what I want to say now about those two subject matters, being a judge and how we think about the law, will be of interest and of utility, of use to you. I hope I'm not, in my old age, as it were, being too romantic about this, that is, too idealised. But I've been thinking about these things for a long time. And I wasn't sure what to say today until yesterday. And the reason I chose these listening to people yesterday at the 70th anniversary conference of the Indonesian Judges Association, where the kinds of ideas that I wish to talk about today were evident in what people were saying. So the first topic that I want to talk about today is about being a judge and judicial technique and approach. Because as I said, it has fascinated me since becoming a lawyer and especially since becoming a judge. What is it that we do? How do we do it? What is the nature of the power that we have? Because we have power, judicial power. And what is the legitimate relationship between words, rules, principles, logic, and intuitive result, and intuition? Those questions seep into even the smallest and most mundane problems that we face. There is a difficulty in identifying a starting point in a talk such as this, because there are so few, if any, static points of definition at which to begin. What I want to say is not just broken up into parts, it's about the humanity and the subtlety of much of what we as judges do. What I will say does not lessen the strength of will necessary for judicial office and judicial work, but it may explain the nature of the task that we face and why our society needs the strength, the humanity, and the learning of an independent group of judges. I think one can commence by some general observations about law and the judicial task, the job we do, which are both timeless and contemporary. Law, in its form, has a number of material elements. It has statutes, the interpretation of statutes, some judicial rule-making, including principles of application and custom and informing principle and values. And these are imperfectly segregated or divided types of material that are drawn from parliaments, the executive, history, custom, values, social mores, and expectations that are human, societal, and by reference to activity within society. And how all these materials combine and coalesce and come to be in the right pattern for a particular problem are both legal and social questions. And that must be so because law is the binding agent of society, or a binding agent. These qualities in turn demand that the social structure and the form and content structure and its form and content rest on consent, respect, trust, and confidence. And this involves a broad democratic consent to power, to judicial power, its sources and its methods of application. It involves faith and trust in the integrity, but also the competence and learning of the judiciary. Our social and legal structures and forms, because they're human and because they are concerned with manifesting human relationships, reflect human values, practicalities, and felt necessities. Each society has some form of division of power. We differ how some power is distributed, but broadly we divide power. And the division of power is born of wisdom from practical experience. Because too much power in one place leads to difficulty. And so, trust in judicial power is, if you like, built on a form of mistrust of having too much power elsewhere. And so, it's the first important reconciliation of opposites, that is, of trust and mistrust. The reason people trust the judiciary is to wield power of a particular kind. And that particular kind is a protective power. To protect, to decide rights, to decide obligations fairly, dispassionately, and wisely, and to protect people from other power. Involved in that, in our daily work, are some opposites, some irreconcilable, some apparent irreconcilable. Let me begin by explaining a few of those opposites. Because these opposites aren't just within the law, they pervade life. And they're the core of our work. Certainty and uncertainty. Rule and principle and exception. The difficulty, sometimes impossibility, of defining something, but the absolute the essentiality of the requisite degree of definition, of some structure of organised ideas. The need to express abstract ideas about concepts that are human and experiential. The power of words, the power of text, but the limits of text. These kinds of opposites actually involve our daily life and our daily work in the simplest of problems. And sometimes we express the law for those whom we decide cases, and we have to reconcile the kinds of certainty and uncertainty, words and feelings that combine to make a system of civilised law. Judges who form or comprise courts hold a position in expressing doctrine and rules, clarifying rules, and most importantly, affecting, impacting the lives of people by their deployment, by their use of power. This effect of power on people involves the need to resolve controversies or disputes between subjects, between people, including the state, the government. But this power's ultimate purpose is unique. It's quite unique because its purpose is to protect people and society by upholding the law and by resolving controversies peacefully, fairly, with dignity, and where appropriate, mercy. Its essential character is protective, not assertive, as other power is assertive, and it's unique in that regard. This power that you have, that you wield on a daily basis, is not possible to define, but it can be described. It is power that is felt emotionally as well as understood in abstracted terms. A sentence of the person, the pronouncement of the order for custody of the child, the sequestration of property in bankruptcy, the judgment for an amount of money that may ruin someone. These are deeply moving and sometimes harmful consequences on people. And they must come from people such as you, who are disinterested, fair, decent, human in character and appearance, but aloof and abstracted to a degree, trusted and respected in your wisdom and learning, with a recognition that you act selflessly, charged as, I use the expression, manifestations of just state power. Though with a humanity that involves the possibility of human failing. These are the opposites that I talked about earlier. And such people as you and myself, as agents of the state, are to be free of partisan considerations, free of anger or love, and hence the judicial oath we take, and you would take a similar oath, I'm sure. And that is to exercise power without fear or favour, affection or ill will. uncertainty, the evaluation, and the struggle with necessarily present opposites in many, if not all, contested questions is difficult to grasp for even trained lawyers. But even when grasped and accepted, there is the question of the disputed views in the resolution of these opposites in particular cases. We disagree about cases. How can it be that we disagree about cases if there is a rule? It's because there are rules, but there are other things. Principles, values, context, judgment, wisdom, a sense of right and a sense of justice. And so how do we recognise that this body of opposites is not to be feared? This is not to say, and I mean this most sincerely, this is not to say, indeed far from it, that there is personal a personal or embedded incoherence in the law. There is not. But it is to say that there is always the need for the presence in the exercise of this power of the fundamentally important elements of judicial technique. I'll now talk about judicial technique. I will later talk about judicial legal thinking, and that's how the two topics I discussed earlier will relate. But I want to talk about judicial technique for a moment. And this technique is important because if it's clear that this technique is your way of approaching problems, even the most hardened or cynical litigant will have a respect for and a trust in the decent exercise of judicial power that may affect that person. So what are the important elements of this judicial technique? Skill, thoughtful learning born of lifelong study about what you do. You never stop learning. Impartiality, diligence, reasonable speed in producing your judgments, a faithfulness to precedent and authority where binding, a faithfulness to properly construed statutes and text, fairness, a rejection of partisanship and a rejection of loyalty to one side, and a lack of anger or emotion, the application of reason and practical judgment, but importantly, with all those abstract ideas, a respect for the dignity of all before you, and an empathy or sympathy even sometimes for those people before the court who are powerless in their reduced position of being put into the hands of the judgment of others and the dependence upon the judgment of others, you and their lawyers. The importance of all these qualities is derived from the relationship between the human and the abstract. Independence of a judge and independence of a judiciary is both abstract and human. certainly in our country, in my country, we assess bias of a judge by putting in place a reasonable person in the courtroom. And so it's not just an abstract idea, it's how would a reasonable bystander view what is happening in the courtroom. Because for the judiciary to succeed in its protective function, it must enjoy the trust and confidence of its citizenry. Not some of it, but all of it. The trust of society. And that trust ultimately derives from the confidence in the lack of partisanship in the courts in the execution of their task. And in the presence of that judicial technique to which I refer, not personal assertion because you have power, but the use of the judicial technique to resolve disputes and to protect the individual and society. And for that trust to be secured and maintained, the law and legal doctrine can never be allowed to become the tools of the powerful. To become the tools of the powerful is the greatest danger to the administration of justice in a democracy. The law is anchored in and entwined by and faithful to fundamental moral notions and values, a rejection of unfairness, an insistence on essential equality, respect for the dignity of the individual and of the group, the rejection of unreasonable public power beyond its legitimate democratic limits, beyond its legitimate democratic source, the rejection of unconscionable private power beyond the society's norms of decency, and a humanity that informs mercy and a sense of justice. All these are values and morals which must be approached by judges with the necessary restraint and respect for other repositories of power in society, using the judicial technique that I've discussed, not mere personal choice. It's no accident that, given the horrors of the 20th century, the first half in particular of the 20th century, in particular in Europe, it's no accident that those horrors spawned certainly in Western societies, in England and America, a desire to move away from the intrinsically human in the face of the capacity for evil of the human. And in legal theory, certainly in Europe, in English and continental Europe, that led to a movement where philosophy and law were seen as separate from morals, which were personal, leading to a form of legal precision and legal positivism, which left morals outside the door. But the same horrors in the 20th century also encouraged a revival in moral philosophy in Europe and England, and an insistence in legal philosophy, an insistence on objective good of some values common to all thinking beings, which give us a larger and ethical metaphysical structure, without which we become confused. And I think in this society that has never left you. But the judicial technique that I've discussed owes its legitimacy to disinterested, impartial and fair expression of meaning and rule from text, and also from context. At this point, what I would like to do is to just stop and reflect for a moment upon what I've said so far, because it's at this point that I would like to change the focus of what I want to say away from morals and values and rules, to say a little bit about brain and how we think, and to discuss with you the work of a very important the great gift that we have as judges is serving our communities, our community, in wielding a power that resolves disputes peacefully, and through doing so protects the rights and values of people in our community, and so helps protect the democratic structure and peaceful existence within our society. And involved in those decisions are almost always conflicting opposites, or apparently conflicting opposites that have to be reconciled. And that's the great challenge for us as judges. And what I now want to talk about is really an explanation of some of those things that are involved in the judicial technique of reconciling opposites, to which I've already referred. What I'm about to say, I have been thinking about all my life as a lawyer. But until I read the work of a particular Scottish neuroscientist recently, in the last 10 years, I didn't appreciate that it was my brain and other people's, just as other people use their brains, were thinking about these kinds of problems that as judges we face. The man's name is McGilchrist. He began life his adult life as a student of literature. He was fascinated by literature and history and politics and philosophy, but he began his life as a student at Oxford University as a literature student, and he then taught as a teacher at Oxford English literature. And he became fascinated, absolutely fascinated, by the inability of words, the inability of text to express important ideas, to express important emotions, to express experience other than in a fairly brutal, precise way. He became so interested in this after writing his first book on criticism that he decided, as one does, now to study medicine and the brain to try and understand why he couldn't express important ideas in words. So he became a psychiatrist and a neuroscientist. And in his work, he discusses how the brain works. And our brains are designed, as many animals' brains are, with two hemispheres, with a left hemisphere here and a right hemisphere here. And they are asymmetrical, they are separate, and they are connected by tissue underneath them. And that tissue underneath them does not transmit, is not there for transmitting, it's there for blocking. So the two hemispheres are able to deal with what is before you, what is before the person, at the same time. Now you're saying, why is he talking? Why is he telling us all this? He's a judge, we're judges, he's supposed to be a judge. Why am I telling you this? Because when I tell you this, you will begin to understand exactly how lawyers approach problems and how lawyers should approach problems. And it's the same for everyone in society, but we're lawyers and we're judges, so we have to think about solving legal problems. Okay, the left hemisphere, which is the right eye and controls the right side of the body, the left hemisphere is centred on the small piece, breaking up things into their order, into logically preparing a taxonomical or organised body of pieces broken up from the whole. Now, does that sound familiar? It should, because that's what we do. That's how we as lawyers look at problems. Okay, this happened. What are the essential elements of it? What is the best order of those small parts to explain what happened? And then when we have thought about them, we write them out and we put them into rules and categories and pieces of ideas and abstractions. We step back and we pull apart the experience in front of us into writing and order and logical precision. And then we call that sometimes reality. But of course it's not reality. The reality is the whole of the problem. The right hemisphere on the other hand, looks at the whole and the interrelationship of the overlapping values and context before it. And the example that McGilchrist always gives to start with to get you thinking about the problem is the bird in the middle of the road, pecking away at the grain on the road, using the left hemisphere and the right eye to look at and find the little pieces of grain. And meanwhile, the left eye and the right-hand side of the brain is looking for danger and context and the eagle, so that the bird on the road is not someone else's food in 2 minutes' time. And so they are both looking at the same thing, but they are attending to different aspects of it in a different way. Now, why is this important for legal thinking? Because it is. Law is a system of rules and principles by which human society controls and mediates behaviour of the whole, of the part, and of the individual. It's within a human society, and it organises human society. It's built on abstraction. It's built on organised expression of order. Or at least those societies such as ours, or parts of our society, that depend on writing. Other societies built on oral tradition may be different. But to the extent our societies are built on text, on writing, we organise our text in a logical way to set out rules and principles and values. But ultimately, our law is more than rules and text. Meaning is often, indeed probably always, anchored in not just the words, but in context. And so words and rules and values need to be placed in context. And so there is a central, and I think a central generalisation about this notion of how the two parts of the brain are attending or focusing on a problem. The left hemisphere has a tendency to deal with pieces of information in isolation, breaking them down and organising them, reorganising them and representing them, whereas the right hemisphere has a tendency to deal with the whole of the subject, its shape, its relationship and its context. And I think for lawyers, these are matters worthy of deep contemplation. When I read his book for the first time, I could see all my colleagues and I could see myself. How many of your colleagues and how often do you just get wound up in the definition and get confused? How many of you do not look at the context? how many of us ignore what the question we are trying to answer is. At the same time, it's of no use to a lawyer or a judge not to try and understand what all the parts are. You have to understand what all the parts are. You have to understand what the text seems to say. You have to try and organise all the pieces of information. But you have to also say, what am I dealing with here? What is the problem that I have to solve? And what is its context? When I read this man's book for the second time, I realised I wanted to have him speak to my judges in the federal court. So with a university, we brought him out to Australia, and he gave a lecture, a much better lecture than this, because he's a brilliant man. And he was before my judges in Sydney at a big judges meeting, just like this, about the same number of people. And one of my really intelligent judges, difficult man, very difficult man, but very intelligent, put his hand up. And he said, all very interesting. But if you were to give us one piece of advice as judges, what would you do? What advice would you give us? And McGilchrist looked at him and said, that's a very good question. And he thought for a moment, and he said, always ask yourself this question: when should I stop writing? When should I stop trying to define this? And later, when I was talking to McGilchrist, and we've become quite good friends, I said to him, it's really, I'm not sure that that's the right question. I said, what you've done for me is to make me at all times ask myself the following questions. What is this question I'm answering? What's its context? And what is the correct, not correct, there's no, what is the appropriate focal distance to think and look at, think about it and look at it? And once you ask yourself those questions, you realise that this may be a different question to the one that you dealt with yesterday. This one may be about criminal law, and yesterday's was about torts and compensation. This one may be a constitutional question, and that was a construction of a constitution, and this was a construction of a statute. And these questions of what is it that I'm looking at, what is it that is being asked of me, and what is the correct focal distance to think about this problem, helps you work out where you should be thinking and what you should be writing. I'll finish in a minute, but and thinking about things in this way has helped me understand a particular problem we have in Australia. I don't know whether you have it in Indonesia. And that is the way statutes are drafted in Australia now. They are long, difficult to understand, broken up into pieces, and go for page after page after page after page. And if you have the time to read the 200 pages of the statute, you might find the answer. But to read it from beginning to end, it's almost incomprehensible. And the problem with that is that the person who's written it has not understood that at some point you have to stop writing and you have to create a narrative that tells you something about the whole. And it's like, it's almost as if someone has taken apart the engine of a car and put it on the ground and said, well, that's a car engine. And you say, no, it's not. It's all the pieces from the car engine. But you say, no, it's the car engine. It's all there. And I guess this is what I'm trying to convey. And that is that there is this body of opposites that I spoke about early when I began, that the part is part of the whole, and the whole is made up of parts, but it is still an experiential whole. And what we deal with as judges are the disembodied rules, the abstract rules that are absolutely essential. We can't have law without organised. If we are going to have a legal system built on writing, we can't live without taxonomy and definition and precision. But we can never lose the reality that they are only expressions of what is a human whole. It helps to understand how we think about what we do. No, less than that. And let me leave you with these simple ideas then. Why is that all helpful, if it is? We all crave certainty. It's a human instinct. Certainty in life, certainty in relationships, and certainty in law is essential. But there is no such thing as ultimate certainty. It's the requisite degree of certainty for the problem at hand. And that is understood by understanding what you are dealing with and the correct focal distance to understand it. And I'll finish with the last paragraph of the paper, which I've made available if the college wishes to translate it. But a friend of mine, a colleague, a judge, a colleague of mine has an abstract work of art in his room, and it's grey and white and black, very forbidding, and it has written in the painting, "The world is ruled by language." And I turned around to him and I said, the artist seems to have left out an important qualification. And he said, "What's that?" I said, "The world is ruled by language, but understood by context." Thank you.
Thank you very much. Thank you very much. Yeah, the last sentence is very important. The world is ruled by language, but understood by context. Sebelum saya buka tanya jawab, saya ingin highlight beberapa isu yang disampaikan Chief Justice James Allsop ini relevan dengan tugas kita sebagai hakim. Meskipun ada perbedaan antara common law dengan civil law, di mana common law hakim pada prinsipnya adalah membuat hukum, a judge made law. Waktu kita kuliah di sini, civil law cirinya adalah a judge implement the law. Dalam perkembangannya, dua sistem ini tidak jauh berbeda. Di Indonesia juga seperti yang tadi disampaikan oleh Chief Justice, statute atau undang-undang memiliki banyak kelemahan. Di antaranya adalah sulit difahami, dan itu juga terjadi di sini. Bahkan kadang-kadang rules-nya sudah tidak relevan dengan konteks sekarang. Ada conflicting rules di dalam undang-undang. And in many cases, the rule of absence, there is no such rules. Sementara hakim tidak boleh menolak, memeriksa, mengadili perkara. Jadi bagaimana hakim harus menyelesaikan perkara, menurut saya apa yang disampaikan oleh Chief Justice sangat relevan bagi kita. Ada aspek technical, judicial teknik, di mana kita harus mampu mengkombinasikan berbagai faktor tadi. Ada juga judicial thinking, judicial teknik dan judicial thinking. Ini harus kita kelola dengan baik sebagai hakim untuk bisa menyelesaikan sengketa secara proper. Dalam sistem kita, Chief, kita sudah mengenal para hakim ini apa yang disebut dengan judicial activism. Ketika undang-undang tidak jelas, ketika undang-undang menimbulkan banyak penafsiran, ketika undang-undang mengandung conflicting principles, not easy to understand, maka di situ hakim di Indonesia berwenang untuk mengeluarkan penafsiran melalui judicial activism. Apa yang disampaikan oleh Chief Justice James Allsop sangat relevan dengan tugas kita terkait dengan judicial activism. Silakan kalau ada pertanyaan mungkin dari ruangan ini dulu. Nanti yang hybrid online bisa juga ajukan pertanyaan. Nanti Pak Arya akan forward ke saya melalui WA. Saya persilakan dulu dari sebelah kiri satu, sebelah kanan satu, ya. Kira-kira ada 4 pertanyaan di ruangan ini, setelah itu kita lihat di online-nya. Silakan sebelah kiri. Satu saja, yang belakang duluan Pak. Ya silakan, angkat duluan tadi. Make it singkat, karena kita pengen explore ya pendapat beliau. Silakan Mas, dari?
Terima kasih Yang Mulia, saya Ferdian Permadi dari Hakim Justisial Kepanitraan Mahkamah Agung Yang Mulia.
Silakan.
Terima kasih kesempatannya Yang Mulia. Yang Mulia, Honorable James Leslie Bain Allsop, Chief Justice, Federal Court of Australia. As you know, Indonesian Judges Organization, as called IKAHI, yesterday celebrating 70th anniversary. And one of the expert of the source in talk show yesterday, named Mr. Rocky Gerung, said that integrity is hard to achieve if the judge's basic needs still not fulfilled. What do you say about that opinion as a Chief Justice and after 20 years expertise as a lawyer? Do you agree to the statement? The second one is, after 20 years practicing as a lawyer, long time ago, do you have any kind of disappointing moment about the weakness of Australian court or the system of Australian trial? And now after you became Chief Justice Federal Court, have you fixed the weakness? Thank you.
The difficulty of integrity to reach the integrity of the judge to reach.
The integrity
Yes.
Yeah.
One of the speakers yesterday said integrity is no easy one to reach, to realize.
Well,
I agree with that.
I think integrity is one of the two pillars of the confidence in the judiciary. It's integrity in the decency, honesty and fairness of the judiciary. The second is the competence of the judiciary. It's not a qualification, it's a reality of the humanity of judges. There will be times where judges fail to meet standards that are expected of them. What is fundamental is that there is an ultimate feeling and confidence in the integrity of those and the competence of those who are placed before the public to solve their disputes. Now, the one thing that I think that I was trying to express early is that if there is an underlying confidence in the integrity of the system and of judges within it, the failings of humanity can be accepted as long as there is a deep feeling that within the community that the judiciary as a whole is and strives for as the standard both personal integrity, fairness, impartiality and competence. And I think that's all I could say. I'm not sure if that's an answer to your question.
Yeah, the second one, please.
Which was, sorry, I'm old.
You have a disappointment?
Oh, yeah. Oh, lots of disappointments. I have a category. I have a category of High Court judgments that I disagree with. I tell them occasionally, but they don't listen. No, look, 22 years and I'm about to finish because I have to at 70. My journey in that 40-odd years, 42, 43 years, since nearly 50 years, I suppose, 50 years, since leaving university. And I was a school teacher to start with. Has been in a sense a journey from thinking that law was about abstract ideas to realising that law is a mixture of abstract ideas and people. And all the failings that I saw in others and myself were mainly drawn from abstract analysis. Most of the problems that I've seen in my own legal system are simply a product of the fact that the legal system is made up of people. And perfection is not possible, but what one needs is underlying moral notions to guide parts of society, such as the judiciary. And that's why the Association of Judges, this college, and the striving for the kinds of notions of justice that can't be defined by the left hemisphere. This is ultimately, let me just go back to what I was talking about. There are lawyers and judges in my society who say law is different from justice, law is law, and that's it. And justice is a moral term that you can have your own justice. And I just think that's nonsense, with respect. Law is the foundation of justice if justice is built on equality and dignity and the respect for the dignity of the individual and of the group and of society. But the important thing to understand is you can't define justice. But because you can't define it doesn't mean it doesn't exist. It's like saying, I can't put a price on that, therefore it doesn't have value. And these are the two parts of the brain that are working. And definition is essential, but it's not possible always. And failings in systems and failings in people are overcome ultimately by the system being stronger as a whole, I think.
Thank you very much. The second here, ada lagi? Dar. Silakan Pak Sabar dulu, silakan yang depan. Silakan Mbak. Feel free aja bahasa Indonesia, ada translatornya.
Tes 1, 2, 3, terima kasih. Thank you, Hanor. My English is not fluent. Let me ask in bahasa. Oke. Hakim dalam putusannya akan mempertimbangkan azas keadilan, kepastian hukum dan kemanfaatan. Hakim harus mempunyai independensi yudisial dalam menjalankan tugasnya. Sementara hakim tidak lepas dari pengaruh opini publik, perspektif sikap, dan sosial background-nya. Yang saya ingin tanyakan, sesuai dengan pengalaman yang mulia. Bagaimana caranya hakim mempertajam rasa keadilan dalam dirinya dengan segala keadaan-keadaan tersebut? Itu saja. Terima kasih.
A very good question. By recognizing the task, I think, is the first thing. Recognizing what it is that you are asked to do. Let me give you two stories. Very often these things are better explained by stories than by definition. The two stories are quite different. The first story is this, and it's a true story. I was at a music recital with a colleague some years ago, and she was hearing a criminal trial of a man who had been accused, and in fact that very day the jury had found him guilty of murder. She did not think personally, she had heard all the evidence, she was the judge and the jury decided guilt. She did not think he was guilty of murder. He had certainly stabbed the man to death, but he had no cognitive function, and he had been told to, he was almost like an automaton. He was guilty of manslaughter and a serious criminal offence, and would probably, as being found guilty of manslaughter, would go to prison for some years. But as guilty of murder, she was obliged to give him a prison sentence of at least 20 years. And we were at the recital, and the violin music simply began to make her cry because she was being overwhelmed by these feelings of having to sentence this man the next day for something she did not think he did, although he did the act. And I said to her, and we left because she was in tears. It was quite, I didn't know what was happening. I know Rachmaninoff, the composer, has effects on people, but I'd never seen this. And we went outside and she told me what was wrong. The violin had just set off these emotions in her, then she was going to have to sentence a man to 20 years in prison, or 25 years in prison tomorrow. And I said to her, you're a human. All these emotions inside you. I said, but you have to withdraw. This is these opposites that I was talking about. I said, you have to realise what you are tomorrow. And that's when I first used the expression that I used with you today. I said, you are not a person. You are not a person. It is not you sentencing this person. It is the state. This is the system. And you, tomorrow, are the manifestation of just state power. And we spoke a few days later, and she said it was the only thing that got me through the day, thinking that it was not me doing it, it was me as a manifestation of just state power. But at the same time, it was that humanity that she brought to what she was doing. It would have been done in a way that would have exuded as much mercy as she could have exuded to this man. And so it's understanding what you're doing and recognizing that if you are hearing a case and you just don't like the person, you have to put that to one side. You have to put to one side what, as best you can. And if you think you cannot put to one side your dislike of the person, then you should not hear the case. You should recuse yourself and say, I don't think I can deal with this in an unbiased fashion, to speak to your chief judge. But that's our task, and I had to speak to one of my judges the other day who found the case she was dealing with distasteful. I said, well, that's what you signed up for. You just put that aside and you hear this case. We don't get to not hear cases because we don't like the subject matter. Now, what was the other example? No, don't worry, that's enough of an answer. I think that explains, it's hard, but it's the task we have to understand.
Yeah, well, it's very clear. Pertama harus memahami dan mengakui tugas berat kita, ya. Itu sudah step yang bagus. Masih ada lagi dari sebelah ujung? Kalau tidak ada, sebelah sana Pak. Itu masih ada satu lagi, kemudian nanti Pak KPN Bekasi. Silakan Mas.
Terima kasih. Assalamualaikum warahmatullahi wabarakatuh. Yang kami hormati Bapak James Leslie sebagai Kepala Ketua Pengadilan Federal Court Australia. Yang kami muliakan, yang mulia Bapak Syamsul Ma'arif, Hakim Agung Republik Indonesia, Mahkamah Agung Republik Indonesia. Sebagaimana topik yang disampaikan tadi adalah tentang hakim dan hukum, sedangkan tentang hukum telah ditanyakan oleh teman kita tadi. Saya hanya ingin tahu sebagai perbedaan, sebagai perbandingan, advokat dan hakim itu adalah satu hal yang sangat dekat sekali. Kalau di Indonesia advokat itu diangkat oleh advokat dan disumpah atau dilantik oleh Ketua Pengadilan Tinggi, bagaimana di Australia? Siapa yang mengangkat dan siapa yang menyumpah? Kemudian dan bagaimana tentang kekuasaan Federal Court di Australia? Apakah hanya menyangkut wilayah tertentu atau menyangkut semua wilayah di Australia, atau hanya isu-isu tertentu? Terus yang ketiga, kalau tidak salah kami tahu bahwa di Australia pengadilan tertingginya itu adalah High Court. Lalu apa hubungan atau bagaimana pembagian kerja atau semacam pembagian kerja begitu antara Federal Court dan High Court? Pertanyaan selanjutnya hanya yang nomor 4. Berapa jumlah hakim agung di High Court? Sebagai perbandingan di Indonesia, hakim agung berjumlah kurang lebih 50 orang untuk masyarakat Indonesia yang jumlahnya 300 juta. Okay. Dan siapa yang mengangkat ketua pengadilan High Court di Australia dan di Federal Court? Terima kasih.
Oke, nanti pertanyaan berikutnya yang prinsip ya, yang teknis seperti ini, itu bisa dicari nanti di web itu. Tapi barangkali Pak James bisa merespons secara singkat sistem peradilan di Australia.
Yeah. If I may say, again, a very good question. To understand where the federal court fits in, you need to understand our political structure. Australia is a federation where we have leave aside the territories for the moment, it's too complicated, but there were Queensland, New South Wales, Victoria, Tasmania, South Australia and Western Australia. and they were separate colonies, having taken the land from the indigenous people, a process of reconciliation that's still going forward. And they were separate colonies, and they combined in one nation that was still an overall colony and is now, of course, independent country. So we have a nation which is a polity, and we have states which are polities, political systems. Each of the states and the Commonwealth has a parliament, an executive, and a judiciary. Each of the states has a Supreme Court. The Commonwealth has a federal court which is the same level as the Supreme Courts. And above everyone, the ultimate court of appeal, Cour de Cassation, is the High Court. There are 7 members of the High Court. The Commonwealth government appoints the members of the High Court. The Commonwealth government appoints the judges of the federal courts. But once appointed, they cannot be removed without address from both houses of Parliament for proved misbehaviour or incompetence. And so, and each of the there are some powers that the states have that the Commonwealth doesn't. There are some powers that the Commonwealth has that the states don't. And there are a mass of powers that both the Commonwealth and the states have. But if there is legislation of the Commonwealth, it negates and avoids legislation of the states. So what we are is we are the national or continental court of all federal, all Commonwealth matters. And we share jurisdiction with the state courts. We often have the same jurisdiction as the state courts. Sometimes we have the jurisdiction and they don't. Sometimes they have the jurisdiction and we don't. But the important thing, this is a very quick constitutional lecture, but it's all that you need for the question. But it's not just Commonwealth statutory issues. We have jurisdiction in relation to the whole controversy if the controversy between the parties has within it a Commonwealth statutory issue. So there might be a great big controversy about a whole range of things. We decide it all if within it there is a Commonwealth statute. So that, I hope, is a broad description. And so we are the same level, if you like, as a state Supreme Court, and above the state Supreme Courts and us, there is the High Court, of which there are 7 judges.
Ya, nanti kalau
And we have 53 judges in our court, which is about the same size as the biggest of the state Supreme Courts.
Okay, very good. It's complicated systems, tetapi bisa menghasilkan putusan yang konsisten. It's not easy. Silakan Pak Ketua BLDK.
Terima kasih. Assalamualaikum warahmatullahi wabarakatuh. Mohon izin saya bertanya dalam bahasa Indonesia. Yang mulia moderator, izinkan saya menyampaikan rasa takut saya berbicara di sini. Karena pengantar moderator tadi mengatakan being judge future. Saya langsung terbayang bagaimana nanti ke depan keadilan demi irah-irah putusan demi keadilan berdasarkan ketuhanan yang Maha Esa. Sanggup enggak kita ke depan? Jadi mungkin pengen kami mendapatkan modal di sini supaya tidak salah langkah ke depan. Namun saya bicaranya judge now aja. Karena apa? Karena saya kaitkan dengan Chief Judge Federal Court tentang kepastian hukum dan keadilan. Di negara kita ini, keadilan itu sudah dibuat, tapi persentase kepastiannya itu sedikit. Azas yang mengatakan res judicata pro veritate habetur tidak jalan. Maaf, saya tidak melakukan penelitian, tapi saya mengalami beberapa kasus yang sudah diputus oleh hakim sekian puluh tahun yang lalu. Itu justia belen cuma mendapatkan putusan saja di atas kertas, tapi haknya tidak kembali. Kenapa? Karena kekuasaan kelihatannya besar di Indonesia. Si Montesquieu mengatakan pemisahan atau pembagian kekuasaan, tapi kekuasaan lebih kuat daripada hukum. Mungkin bisa diberikan sedikit kekuatan kepada kami bangsa Indonesia ini. Seperti apa Mahkamah Agung Amerika itu memberikan kepastian kepada warganya. Australia. Iya. Kalau John Rule itu mengatakan keadilan itu berpihak kepada rakyat kecil. Kalau kita mengacu ke Abraham Maslow tadi, kebutuhan kita itu ternyata hukum itu hanya di tengah-tengah. Negara kita itu sibuk mengurusi politik, negara kami, sibuk mengurusi kemiskinan, sibuk mengurusi ekonomi, sibuk mengurusi harta kekayaan. Itu saja, mohon maaf kalau saya tidak tertib. Assalamualaikum warahmatullahi wabarakatuh.
I want to add a point. Jadi ada dogma, semacam dogma yang diberikan kepada calon-calon hakim. Ada 3 nilai yang harus dikombinasikan sebagai hakim dalam putusannya. Kepastian, keadilan, dan kemanfaatan. 3 nilai ini yang selalu disampaikan kepada hakim. Setiap putusan harus mengandung 3 nilai ini. Nah, banyak di antara mereka menanyakan bagaimana kita bisa mengkombinasikan mana yang lebih kuat dari yang satu nilai dan seterusnya. Gitu. Sebagai tambahan dari pertanyaan tadi. Please. Fortunately we have only 5 minutes, but 5 minutes. Thank you.
5 minutes for the hardest question. One can only do what one can. And if one cannot rely on others, it does not mean that one shouldn't keep relying on oneself. No system is perfect. Each part of government relies on the other part of government doing what it should. Part of judicial power, part of the respect that judicial power should have comes from judges recognising the limits of what they can do. And it's the riddle that if you see other powers not doing what they should, to step in and do their job will destroy your position and not do their job either. And so the respect that the judiciary gets ultimately comes from the people who stand in front of you. And if they know that the integrity and the fairness and the impartiality of which I spoke is present, if they know that your solution to their problem comes from your fair use of judicial technique, and if they respect you for what you do as far as the limits of your power take you, there's nothing more you can do. But that doesn't mean that what you've done is useless, far from it. Those people leave the courtroom knowing that the judiciary understands its task, approaches its task properly, and has the respect of those whom it serves. If there be deficiencies in the way others deal with their responsibilities, the system has to somehow cope with that, and but to step in and overstep your responsibilities and your roles, I think ultimately leads to the loss of your authority. I'll give you one more example of very early on in my judicial career. I had what I thought was a terrible case. It was the first of many of the deportation from our country of an adult who'd come to our country as an infant, as a baby, but had never become a citizen because of carelessness or lack of interest, and had committed a criminal offence and was being sent back to a country to which they had no allegiance, no language, no connection, that would lead to almost certain personal catastrophe. I could not do anything. It was not within my power. If I came to the view that the Minister of Immigration had lawfully come to this decision under the statute, as I did, I thought it was inhumane, I thought it was cruel, but it was not my power. And we face these kinds of things. Like my colleague who sentenced the man to 25 years, when she was certain that he should not have got more than 5 or 6 or 7. We just have to do these things. And the fact that someone else is not exercising their power properly is not a reason to overstep our power.
Great. Thank you very much. Diskusi yang sangat menarik, tetapi karena waktu kita tidak bisa lanjutkan ini. Tetapi intinya sebagai hakim tidak hanya membutuhkan judicial teknik, tetapi juga judicial thinking. Bahwa dunia dalam banyak hal memang diatur oleh language gitu. Tetapi bahasa itu baru bisa bermakna ketika kita baca dalam konteksnya. Kira-kira itu yang bisa saya underline. Ya. Tentu saja kita ucapkan terima kasih kepada Chief Justice Allsop. Thank you very much. going with us. Thank you.
Thank you for having me speak. It's been a privilege to be here.
Baik, terima kasih moderator kita pada hari ini yang mulia Bapak Syamsul Ma'arif. Boleh kita berikan aplaus yang meriah Bapak Ibu untuk diskusi kita pada pagi hari ini yang luar biasa. Setelah ini kita akan melaksanakan penanaman pohon, namun Bapak Ibu para peserta kami mohon sedianya untuk tetap di tempat. Namun untuk yang mulia Chief Justice dan yang mulia Pak Syamsul Ma'arif kami mohon untuk menuju tempat transit karena akan ada pemberian souvenir dari yang mulia Ketua Mahkamah Agung, izin. Namun untuk para peserta kami mohon untuk tetap di tempat karena setelah pemberian souvenir nanti kita akan melakukan sesi foto bersama di depan auditorium. Terima kasih. Cek satu, dua.
Hah? Aha. Sambutan dulu ya? Sambutan dulu.
Oh, di belakang. Oh, iya, iya.
Assalamualaikum warahmatullahi wabarakatuh. Selamat pagi yang mulia dan Chief Justice Federal Court of Australia. Selamat datang di Badan Litbang Diklat Hukum dan Peradilan Mahkamah Agung. Agenda kita pada pagi hari ini adalah penanaman pohon. Untuk itu kami ucapkan selamat datang kepada Yang Mulia Ketua Mahkamah Agung, Yang Mulia Wakil Ketua Mahkamah Agung, Yang Mulia Honorable James L.B. Allsop, Ketua Federal Court Australia, Yang Mulia Bapak Syamsul Ma'arif SH LLM PhD, yang terhormat Kepala Badan Litbang Diklat Hukum dan Peradilan Mahkamah Agung, para pejabat eselon 2 pada Badan Litbang Diklat Hukum dan Peradilan Mahkamah Agung, para hakim tinggi, para hakim justisial, para ketua pengadilan tingkat pertama, para penasehat hukum dari OPDA, para tim pembaharuan Mahkamah Agung, para tim reformasi hukum IPJ, dan seluruh peserta yang berbahagia. Mengawali acara penanaman pohon pada hari ini, mohon berkenan kita awali dengan sambutan oleh The Honorable James L.B. Allsop, Ketua Federal Court Australia. Kami persilakan.
Good morning. As I said to the group to whom I was speaking, that it's a wonderful way to begin a meeting and an expression, and peace be upon it. Peace be upon you. I wish to thank everyone at the Supreme Court and the College for inviting me to Indonesia, Jakarta, to speak to my friends and colleagues at the Supreme Court, to speak to their judges, and most importantly, I think, if I may say, to speak to the college of judges, and including the young judges. It's a great privilege for me to be here to speak, and it's a great honour that you bestow on not me, but my court in Australia for this ceremony. So I'd like to thank the Chief Justice and all his judges, Deputy Chief Justice, and all the judges of the Supreme Court, and all of you who are here today for doing me the honour and doing us all the honour of this ceremony. So thank you. Thank you especially Chief Justice. Thank you.
Thank you very much. Baik, selanjutnya kami mohon perkenannya Yang Mulia Ketua Mahkamah Agung, Bapak Profesor Dr. H.M. Syarifuddin SMH, juga dapat memberikan sambutan sekaligus meresmikan acara penanaman pohon kita pada hari ini. Kami persilakan.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Selamat siang, salam sejahtera untuk kita semua. Om Swastiastu, Namo Buddhaya, salam kebajikan. Yang mulia Ketua Federal Court of Australia, Chief Justice Allsop. Yang mulia para pimpinan Mahkamah Agung Republik Indonesia, serta Hakim Agung Pak Samsul yang hadir pada hari ini. Yang kami hormati rekan dari ODA, Departemen Kehakiman Amerika Serikat, Penika Peterson, Kapita Babu, Subimika dan Emily. Yang kami hormati para badan diklat, hukum dan peradilan, serta seluruh jajaran badan diklat Mahkamah Agung, para pejabat eselon 2, hakim justisia, para lainnya, dan kami juga hadir pada pagi hari ini juga banyak para ketua pengadilan tingkat pertama dari sekitar Jawa Barat dan Jakarta. Yang mulia Chief Justice Allsop, selamat datang di diklat Pusat Pendidikan Pelatihan Mahkamah Agung Republik Indonesia di Ciawi, Jawa Barat. Alhamdulillah, setelah menjalani kunjungan kerja yang sangat padat dan pasti melelahkan sejak hari pertama kedatangan yang mulia, akhirnya kita sampai juga di penghujung rangkaian acara penutup kunjungan kerja yang mulia, yaitu dengan penanaman pohon dan nanti dilanjutkan dengan makan siang. Kami sengaja mengajak Anda kembali yang mulia untuk datang ke sini, meskipun harus menempuh jarak lebih kurang 70 km dari gedung Mahkamah Agung, dari Hotel Borobudur di mana Anda menginap, di mana tadi malam kita sudah makan malam sampai hampir jam 10 malam, dan pagi ini Anda sudah ada di gedung diklat Mahkamah Agung Megamendung. Tidak terasa sudah genap 10 tahun kerjasama Indonesia, Mahkamah Agung Republik Indonesia dan Federal Court of Australia dijalankan di bawah kepemimpinan yang mulia yang mulai pada tahun Maret 2013. Di bawah kepemimpinan yang mulia Allsop, kerjasama bilateral antara pengadilan kedua negara terus berkembang. Terlepas dari naik turunnya hubungan diplomatik kedua negara, bagaimana layaknya tetangga dekat, yang mulia Allsop terus mampu menavigasi hubungan antara kedua pengadilan untuk tetap berada pada posisi yang tetap akrab, kondusif dan profesional. Yang mulia Allsop juga kami ketahui memiliki komitmen yang tinggi terhadap kerjasama ini dan tidak sungkan untuk terlibat langsung dengan berbagai kerja-kerja dialog judisial antara kedua pengadilan, terutama ketika kami sedang memfokuskan diri kepada peningkatan peringkat kemudahan berusaha sebagai prioritas nasional. Yang mulia Allsop terlibat langsung dengan dialog judisial penyiapan kerangka hukum pengadilan elektronik, bahkan hadir langsung dalam public expose draft Perma Court tahun 2018 di Pengadilan Negeri Jakarta Pusat. Dan ketika kami melakukan penyiapan peraturan Mahkamah Agung tentang gugatan sederhana, beliau juga memberikan akses yang luas kepada tim penyusun untuk mempelajari praktek tersebut di Australia. Hal tersebut telah membuat Mahkamah Agung Republik Indonesia menjadi sangat yakin melakukan penguatan prosedur gugatan sederhana. Belum lagi ketika kami menyiapkan penyempurnaan kerangka hukum mediasi, beliau juga sangat sportif dalam menjalani proses tersebut. Hal ini menunjukkan betapa tinggi komitmen beliau dalam menjalani 10 tahun kerjasama ini. Untuk itu, pantas apabila Mahkamah Agung Republik Indonesia memberikan penghargaan setinggi-tingginya kepada kontribusi Chief Justice. Di akhir kunjungan beliau pada hari ini, seperti tadi sudah saya sampaikan, beliau masih bersedia hadir langsung di persidangan kita di Megamendung. Beliau langsung berbagi dengan berdiskusi kepada rekan-rekan kita sesama hakim, baik itu hakim-hakim masih muda maupun para hakim pimpinan pengadilan, dan termasuk seluruh hakim di Indonesia yang mengikuti acara ini secara daring. Sangat bermanfaat sekali. Terima kasih yang mulia. Itu juga alasan kenapa kami mengajak beliau ke tempat ini. Diklat Mahkamah Agung Republik Indonesia di Ciawi adalah fasilitas kebanggaan Mahkamah Agung Republik Indonesia. Kami percaya bahwa fasilitas pendidikan hakim kami adalah yang terbesar di Asia Tenggara dari sisi ukuran. Luas lahan kami kira-kira 2 kali lahan Philippine Judicial Academy di Tagatai. Dengan total tanah kami mencapai 6,8 hektar. Akomodasi yang kami miliki mampu mengakomodasi 569 peserta didik dengan asrama yang mampu menampung 68 orang pengajar. Saat ini fasilitas pendidikan yang tersedia mencapai 11 ruang kelas, 6 kelas kecil dan 3 kelas untuk ruang sidang semu. Tentunya diperlukan untuk mengakomodasi lebih kurang 32.000 aparatur kami dan 8.200 khusus hakim. Kami mengajak Chief Justice Allsop ke sini dengan maksud memberikan kesempatan untuk menanam pohon di sini. Kali ini pohon yang akan ditanam oleh Chief Justice Allsop adalah pohon kelengkeng ruby longgan. Betul ya? Longan. Pohon ini akan menghasilkan buah kelengkeng yang manis dan mengandung banyak nutrisi, serta digunakan dalam pengobatan tradisional untuk berbagai penyakit. Saat ini sudah tidak kurang 12 pohon ditanam oleh Ketua Mahkamah Agung Negara-Negara Sahabat dan pejabat setingkat menteri. Sebagai catatan, Chief Justice Allsop, penanaman pohon merupakan cara dan tradisi kami dalam menghormati orang-orang yang berkontribusi penting bagi peradilan Indonesia, supaya nama mereka abadi di hati kita semua dan mengabadikan kontribusi mereka, karena pohon akan selalu memberikan manfaat bagi kita semua. Yang mulia Chief Justice Allsop, sekali lagi secara pribadi saya ingin menyampaikan ucapan selamat dan penghargaan setinggi-tingginya kepada kerjasama dan komitmen beliau selama lebih dari 1 dasawarsanya dalam membangun kerjasama antara peradilan Indonesia dengan Australia. Telah banyak manfaat yang kami peroleh dari kerjasama ini dan telah menjadi fondasi solid bagi kerjasama bilateral antara peradilan ke depannya. Selamat memasuki masa purnabakti pada 6 April 2023 yang akan datang. Ada hal unik karena tanggal ulang tahun Chief Justice Allsop sama persis dengan tanggal lahir Profesor AKI. Saya sangat berbahagia buat Yang Mulia Chief Justice Allsop karena pengabdiannya di Penal Court of Australia akan berakhir dengan sempurna. Saya berharap pasca purnabaktinya bisa tetap berperan membantu peradilan Indonesia. Saya tahu bahwa Chief Justice Allsop adalah profesor, seorang guru besar dalam bidang hukum bisnis, yang tentunya apabila ada kesempatan di masa depan bisa tetap berbagi dengan hakim-hakim kami di Indonesia. Sungguh Australia kehilangan sosok yang sangat menyejukkan dalam kepemimpinannya dan membawa Federal Court of Australia ke tingkat yang sangat dihormati dan diakui kiprahnya dalam perniagaan tidak hanya di Australia namun juga di tataran internasional. Kami berharap pengganti yang mulia Chief Justice Allsop mempunyai keinginan yang sama untuk dapat melanjutkan kerjasama antara Supreme Court of Indonesia dan Federal Court of Australia. Selamat jalan yang mulia Chief Justice Allsop. Semoga kita bertemu lagi di lain kesempatan dalam keadaan sehat dan bahagia. Amin. Terima kasih. Selamat siang. Wassalamualaikum warahmatullahi wabarakatuh.
Terima kasih Yang Mulia Ketua Mahkamah Agung atas sambutannya. Baiklah Bapak Ibu yang mulia dan hadirin sekalian, sekarang kita akan memasuki penanaman pohon. Penanaman pohon pada siang hari ini adalah terdapat 3, yaitu kelengkeng rubilongan. Kelengkeng merah atau sering disebut kelengkeng rubilongan merupakan varietas tanaman buah kelengkeng, varietas yang paling terbaru dan mutakhir yang berasal dari Thailand dan masih satu turunan dengan kelengkeng aroma durian. Buah kelengkeng merah memiliki ukuran buah berdiameter antara 1,5 cm hingga 3 cm. Selain memiliki kulit yang berwarna menggoda, daging buahnya juga tebal, bahkan tingkat kemanisannya mencapai level 21 Brix. Dan pohon yang kedua yang akan kita tanam pada siang hari ini yaitu kelengkeng HW Matalada. Kelengkeng HW putih adalah varietas buah kelengkeng yang memiliki daging buah putih dan rasanya manis. Buah ini berasal dari tanaman kelengkeng yang tumbuh di daerah tropis seperti Indonesia, Malaysia, Thailand, dan Vietnam. Kelengkeng HW putih biasanya memiliki ukuran buah yang lebih besar daripada varietas kelengkeng lainnya, serta memiliki kulit yang tipis dan mudah dikupas. Dan pohon terakhir yang akan kita tanam pada siang hari ini yaitu durian musangking. Durian musangking adalah varietas durian yang terkenal di Malaysia dan Indonesia. Durian musangking berasal dari kawasan Pahang, Malaysia, dan ditanam di daerah-daerah seperti Johor, Perak, dan Selangor. Durian musangking dikenal memiliki daging buah yang lembut, manis, dan beraroma kuat. Buah ini juga dianggap sebagai salah satu jenis durian terbaik di dunia dan biasanya dihargai dengan harga yang cukup mahal di pasaran. Sebutan musangking ini disertakan karena lokasi pohon induknya berada di dekat Gua Musang di Kelantan. Baik, untuk itu kami persilakan yang pertama kali akan menanam pohon, The Honorable James Albi Allsop untuk penanaman pohon kelengkeng ruby longan. Kami persilakan.
Sorry. Sudah berbuah nak? Betul. Apanya buahnya? Populasi. Oh ya.
Selanjutnya penanaman pohon kelengkeng HW Matalada oleh Yang Mulia Ketua Mahkamah Agung.
Ngadepnya harusnya ke sini.
Sampai nggak maju deh.
Hah?
Sampai nggak maju.
Kabelnya habis.
Terima kasih, Yang Mulia. Selanjutnya penanaman pohon durian musangking yang akan ditanam oleh Yang Mulia Wakil Ketua Mahkamah Agung bidang non-judisial.
Kalau ini tumbuh tinggi berbuah. Ya, gambar awal, Pak. Lihat.
Mas sore.
Musangking. Tanahnya enggak tepis.
Batal ya. Sesuai dengan tujuan peradilan.
Ya, siap, Pak. Ya, sabang, Pak.
Terima kasih Yang Mulia. Selanjutnya Yang Mulia kami persilakan untuk menuju ruang transit untuk menikmati hidangan santap siang yang telah kami sediakan. Terima kasih. Wassalamualaikum warahmatullahi wabarakatuh.
Den, tutup Den.
Mungkin sebelumnya berkenan untuk foto terlebih dahulu.
Dapat nggak nih? Harus sekali ikutin itu lah. Kalau nggak dapat ya. Biar kayu. Oke, ya.
Konvensional.
Sudah. Ke depan ini. Bukan di belakang. Ya.
Udah. Oh, saya kan foto keren.
Kacau.
Konvensional.